Hey guys, today I would like to speak with you about some differences between an eviction action, unlawful detainer action, and ejectment action in Florida. Evictions are covered under Chapter 83 of the Florida statutes. Part 1 of Chapter 83 covers non-residential tenancies, Part 2 of Chapter 83 covers residential tenancies, and Part 3 of Chapter 83 covers self-service storage spaces. Unlawful detainer actions are covered under Chapter 82 of the Florida statutes, and ejectment actions are covered under Chapter 66 of the Florida statutes. Here are some distinctions between the three actions. With an eviction action, there is typically a lease agreement in place, and it states whether the tenancy is weekly, monthly, annually, or for some other period of time. Notice is typically required before you can file an eviction action. Whereas with an unlawful detainer action, the person entitled to possession of the property is not required to notify that prospective defendant before filing the action. Similarly, in an ejectment action, a plaintiff may not be required to provide any notice or pre-suit demand to a defendant as a condition to maintaining an ejectment action. Another distinction with an ejectment action is that circuit courts here in Florida have exclusive jurisdiction to hear ejectment actions. An example of when an eviction action can be used is when there is a landlord-tenant relationship. For example, a tenant agrees to pay a monetary sum of rent to the landlord in exchange for possession, the right to use the subject property. If a dispute later arises and the landlord is now seeking to regain possession of the property, an eviction action would apply. An example of when an unlawful detainer can be used is when you let your former significant other or relative live in your home. You have now told them to leave and they are refusing to leave. In an unlawful detainer scenario, the person did not have an agreement to pay rent, they no longer have permission to live in the property, and they do not have any ownership claims to the property. An example of when an ejectment action can be used is when a person legally purchases a property and records a deed. After the property is purchased, the former owner then turns around and sells the property to someone else. The new buyer comes to live at the property and they claim that they own it since they purchased it from the former owner. Per Florida Statute 66.021 subsection 1, the person with a superior right to possession of real property may bring an ejectment action to recover possession of the real property. To conclude, there are different scenarios where each action applies, and it is very important to make sure that you're filing the correct action based on the specific facts in your case. If you have any questions regarding property in Florida, or you would like to consult with a licensed Florida attorney, our contact information is below. Until next time, have a great day.